Welcome to my presentation on the rights of surrogates. What is an ethical dilemma? Ethical dilemmas are situations in which there is a difficult choice to be made between two or more options, neither of which resolves the situation in a manner that is consistent with accepted ethical guidelines. When faced with an ethical dilemma, the majority of the population will try to choose what's right. But the question with an ethical dilemma is what is right, because what's right for you may not be what's right for me. What are stakeholders? Stakeholders are a person or persons with an interest or concern in something. In this case, we're going to discuss stakeholders and surrogacy. Stakeholders in surrogacy are persons acting as gestational surrogates, children born of such arrangements, and intended parents. What is surrogacy? Surrogacy is an arrangement by which a woman gives birth to a baby on behalf of someone else who is physically unable to have babies themselves and then gives the baby to that person. Sometimes surrogacy can be used for infertility, same-sex relationships, and even just a woman who is single but wishes to have a child. Who benefits from surrogacy? For intended parents, it's the chance to finally complete their family and realize their dreams of parenthood. For surrogates, it's the chance of a lifetime to give selflessly to another family who needs them. For both parties, surrogacy is an extraordinary journey and a deeply rewarding experience, unlike any other. When done correctly, surrogacy truly is an act of kindness. What are the types of surrogacy? For this time, we're going to discuss two different types of surrogacy. First, there's the traditional surrogate. This is when a woman becomes artificially inseminated with intended father's sperm. This woman then carries the baby and delivers it for the intended parents to raise. A traditional surrogate is the baby's biological mother. This is because it was her egg that was fertilized by the father's sperm. Donor sperm can also be used in this situation. Then there's gestational surrogates. A technique called in vitro fertilization, also IVF, makes it possible to gather eggs from the mother, fertilize them with sperm from the father, and then place the embryo into the uterus of the gestational surrogate. The surrogate then carries the baby until birth. They don't have any genetic ties to the child because it wasn't their egg that was used. A gestational surrogate is called the birth mother. The biological mother, though, is still the woman whose egg was fertilized. In this situation, the mother that carries the child is simply a vessel to bring the child to life. There are many requirements in place and able to be a surrogate mother. A lot of these vary from state to state, but the most general requirements across the board are be above 21 years of age and younger than 40. You must have a healthy BMI as determined by your doctor. You should have carried at least one pregnancy successfully to term. You should be raising a child of your own in your own home. You should have no major complications in your previous pregnancies. You should be off of antidepressants or anti-anxiety medications for a minimum of 12 months. You should have no new tattoos or piercings within 12 months of starting the process. You should also pass a mental health screening and be emotionally prepared to carry a child that you will give up at birth. Surrogacy laws in West Virginia. The courts are generally favorable to married, heterosexual couples and will issue a pre-birth order after hearing with all parties. In some cases, same-sex couples are considered and will likely be chosen to be surrogates as well. West Virginia's intended parents must file a petition requesting a West Virginia pre-birth order in the county of the child's birth or in Kanawha County with the Bureau of Vital Statistics. It's unclear whether courts will grant pre-birth orders to unmarried couples. What are the rights of surrogate mothers? Once legal parenthood is established, the surrogate has no legal rights to the child and she cannot claim to be the legal mother. However, in the same vein, the contract protects the surrogate from any kind of legal or medical responsibility for the child. What are the rights of the biological or intended parents? Because of the Parentage Act, there needs to be an acknowledgement of parentage by the courts in order to establish the intended parents as the child's true legal parents. This happens after the baby's birth, when the surrogate and her husband or wife, whatever the case may be, if applicable, signs documents stating they are not the legal parents of the child and that they are relinquishing any and all rights that they may have to the child. These documents are given to the intended parent's attorney, who submits it to the court along with other paperwork necessary to prove parentage. In traditional surrogacy, however, some additional legal steps are necessary because the surrogate is also the biological mother of the child. In these scenarios, the surrogate's rights need to be terminated, and she and her partner, if applicable, will have to sign a contract to relinquish the parental rights. Following termination of rights, the genetically unrelated intended parent will also need to complete a step-parent or second-parent adoption procedure. There are several myths surrounding gestational surrogacy that we should discuss. One myth is that gestational surrogates are the biological mothers of the child. And while this is true in some aspects, it's not always the case. It's also said that gestational surrogacy can only help intended parents who are infertile. This is a myth because it can also help same-sex couples or even single women who wish to be parents. A myth stating that becoming a gestational surrogate is easy and any woman can do it. That's not true. As discussed in an early slide, there are several criteria that must be met before a mother can become a surrogate mother. Intended parents won't have a strong bond with their child. This is also a myth because typically babies born of a surrogate scenario are given straight to the intended parents where skin-to-skin contact is performed and the bonding period immediately begins. And also the myth that gestational surrogacy is too complicated. While it may seem intimidating and complicated at times, it's easily navigated with the right people by your side to advise you and a strong partner to have your back. What is my position on surrogacy and the rights of surrogate parents? I believe that the intended parents, the ones who sought out the surrogate, should have full and complete rights to the child, regardless of whether it's a gestational or a traditional surrogacy. Rights should be established prior to the implantation or fertilization and should be legally binding without question. If you seek out a surrogate to carry your child, it should be known, and it is known immediately, that this is what you want. Why do I feel this way? The intended parents have sought surrogacy for a reason. They want a child, but they cannot conceive. Maybe they're single or they're in a same-sex relationship. The surrogate mother has agreed to carry their child for them, and be it a gestational or a traditional surrogacy, they should abide by the intended plan without question. If at any time prior to implantation or fertilization they feel as though they are not ready for this step, the process should be terminated. Obviously, the surrogate mother can conceive, so she should not offer her services if she wishes to have another child of her own. To me, there really is no gray area here. Surrogacy can be a wonderful, beautiful thing, but it has to be done properly.